morning. So we'll start our section right now. Welcome back to the channel. Let's crack UPSC CSE English. If you have not yet subscribed the channel, please updates. Welcome back to India's largest online platform where you are able to access the top educators at a single destination. About me, I'm Liyamol Biju. I complete as a scholar. I have and more than 3 years of teaching. It's all about this is my Unacademy Telegram. Follow me for the updates and not. This is also my Unacademy profiling on the join me. So in the description box, you'll get the details to join it. Please do join so that you get latest updates, notifications, etc. and much more. So we'll be continuing with the NCRT discussions from tomorrow to you. I was a bit busy. I'm just busy today. That's why I have arranged to morning. Don't worry. MCQ and the timetable goes like that. Tomorrow and day after tomorrow. That is 2 days will be maximum will be the NCRT discussion last 12. If remaining that too, don't worry about it. So tomorrow we'll be having this section at what you get daily live classes, live tests and structured course and unlimited access for enrolling and you can download our app from Google Play Store and from the App Store. About the UPSC optional like live classes, live tests, unlimited. You get a personal coach and daily study planner, personalized feedback if you're joining the iconic loop. Whereas in a plus course, you get live classes, testers, unlimited practice, and schedule structured schedule. So like the plans, 1 month you get it for 9,000 rupees. But don't worry, you can use my user code for any of the subscriptions like BIJ. You get a 10% waiver on the any of the subscriptions. Like 1 month is 1 month it is like you get it for 8,100 rupees. That is you're using. 3 months you get it for 20,000. That is whereas the real fees 22,500 rupees. 6 months like 40. Get it for 36,450. 12 months is like 49,500 rupees and 12 months is like 44,550. 24 months is 70,000 rupees, but you get it for 64,000 and 36 get it for 1,000 rupees. You can use my IJ a fees waiver on 8 of the following subscriptions. We are having a UP optional channel and optional subscriptions now. That is 1 month you get for 5,000 rupees. 6 months, 12 months is 20,500, 24,000. 4 months like is 40,000. But you can use or also you can use my that as BIJU and you get a 10% on each of the following subscriptions. Since I have changed the time, I know like 2 days. I don't have any other options left, but onwards will continue itself. Have changed. Like 1 month is 9,000 rupees per subscription plan, so you can discount it IJU. And what are the four optional subjects? We are getting public administration, PSIL, psychology, commerce and law, sociology, history, geography, Maithili literature, anthropology, Kannada literature, and English. Today's session is really a freaky section. You can evaluate yourself. It's ancient history. Calls you will be evaluating yourself, your answers, that you will, how much you have made, not made correct. And for the four classes, it will be interesting that you will be getting yourself goals. And so the timing is like 8 p.m. 9:30 p.m. is the timing, like 1 hour more. We are starting the first question is like present relationship president and the council of governed by the provision which amendment act. Okay, 42nd amendment act, 48th amendment act, 50th amendment act, 44th amendment act. I think we had discussed something about it yesterday. So once more, please question, analyze yourself, then answer. So what is, I hope you got an answer for the question. The answer for the question is 44th Amendment Act. So when was this 44th Amendment Act passed? You have an idea? Let me tell you, I told you, this MCQ section, we had compared a compilation section where I was not able to complete everything. So I thought, okay, so the rest is, I hope you can answer for the question. The answer for the question is, it is 44th Amendment Act. Answer is D, 44th Amendment Act. Okay. So yeah, we'll discuss it. Don't worry. We'll just have a brief idea what is this 44th Amendment Act. Whatever the points, whatever I'm right now telling, just make a note on it, because this is going to really help you for the final level examination, because you can't go and read everything, right? Everything. It is correct. 1978, the year when it has been passed. 1978 is the year when it is being passed for the first time. Okay, so what is the act is telling about? And so what are the this act has been given on the fundamental rights. So everywhere it has been given different opinions. That is on fundamental rights, Article 19F, which guarantee the citizens a right to equal, acquire, hold and dispose property, and Article 31 relating to the compulsory acquisition of property have been omitted. And what is on DPSP? On DPSP part, on DPSP, that is Directive Principles of State Policy, it have inserted an article known as Article 38 being inserted. So this is much more important. Article 38 is being inserted. And what is it? Let me tell you very frankly, more than the question, the explanation is going to help you to get crack the prelims, because we are dealing with the very minute points and you won't get it from one textbook, especially from your Lakshmikant and all you are reading it. You won't get even the minute details. So nowadays UPSC is having the habit of asking the minute details. So we have to cover it, right? That's our responsibility. So Article 38 is saying to secure social order. To secure the social order is the main thing. And on presidential order, on presidential power, something to do with the presidential power. Article 74(1) is being inserted, which was amended to include the provisions that require Council of Ministers. So here in this Article 74(1) of the Constitution, a provisions, a relationship which mentions between the President and Council of Ministers is being discussed. And of course, it has to do something with the parliamentary privileges too. Parliamentary privileges. Here, Article 83 and 172 was amended. So, what did this do? Like it has restored the terms of House of the People and State Assemblies for 5 years. And what happened? In the 42nd Amendment Act, it was turned to 6 years. Now again it has been turned back to 5 years. So what is the time period of a Lok Sabha? That is 5 years. House of the People, that is to Lok Sabha. And both of the things, Rajya Sabha also was extended from 5 to 6 years, but Rajya Sabha continued, whereas Lok Sabha has been changed. Then it amended Article 103 and 192. Article 103 and 192 was being amended again. What is this being given? According to the provisions, according to the in accordance with the provisions, okay. It will be in accordance with the opinion of the Election Commission on the power of High Courts. Then Article 226 is further amended here. What is this Article 226 with? It is regarding the High Courts and regarding the power to issue. It is regarding the High Courts and the power to amend and the power to restore the rights or issue to writs. To issue or to restore the writs. Then Article 27 is being also amended, that is superintendence of all our courts and tribunals within its duty. So High Courts will have the privilege to look after to the superintendence of all courts and tribunals within their regional jurisdiction. So it is being given. And on federation, so this is something a much big amendment, and Article 257A is being added to it. According to this, relate to the power of the central government to send its armed forces to the union in a situation which is amended. Then Article 352 is amended with a word what is very famous, that is internal disturbance is changed to armed rebellion. Internal disturbance being changed to armed rebellion. So what is this? The proclamation of an emergency is being concentrated on with. What are the other provisions? See that once an emergency is proclaimed within 1 minute, you have to both of the resolution have to be passed by both of the houses of the parliament within 1 month after a emergency provision is being emergency is declared. Within 1 month time period, you have to both the houses of the parliament have to pass it and have to resolve it, and it should be by 2/3 majority. And to continue that, every 6 months, you have to pass it again and again. And what about this? Is about the condition of national emergency. Of course, so there will be a discretion in the state emergency also, which is coming under Article 350 of the Constitution. States would amend also to provide the proclamation issued would be 350 only for a period of 6 months. And you can extend up to 3 years, not beyond that. And Article 358 and Article 19 amended, whereas Article 19 will be automatically suspended if the national emergency is the ground on war or external aggression. That is, if Article 19, during the emergency provision, the Article 19 will be automatically suspended. Okay. But Article 20 and 21 remain and they cannot be suspended. So this is the explanation for Article 44th Amendment Act. The next is 48th Amendment Act. 48th Amendment Act. What is the 48th Amendment Act is all about? What do you mean by 48th Amendment Act? So the 48th Amendment Act was in the year 1984. 48th Amendment was in the year 1984. What is this? It added Article 356 a clause. What is it officially known as the Constitution of 80th Amendment Act inserted a clause 5 which states that Article 256 in the Constitution to provide that in case the proclamation, that is a proclamation of emergency, it should be issued under the hand of the President and to find the resolution. That is not. Since it's issued, you want to know what is 54th Amendment Act. 54th Amendment Act. What do you know about 54th Amendment Act? What do you understand by 54th Amendment Act? You cannot assure that all the amendments will not be asked. You cannot even proclaim like that. What is the highlight of 54th Amendment Act? What is the highlight of 54th Amendment Act? 54th Amendment Act of 1986. Okay, this is the year which it is passed. It enhances the salaries and allowances of a judge of High Court or a Supreme Court is being enacted by the 54th Amendment Act. And then what is another Amendment Act, which is the 42nd Amendment Act. It might be very much important in the current position also. What is this 42nd Amendment Act? And this is one of the most important. The 42nd Amendment Act of the Constitution is one of the most relevant and most important one Amendment Act. It was there is a backstory even for that, and we already discussed it. I'll just brief out other things. So it was headed by the Indian National Congress was ruling over there. Indira Gandhi was then the Prime Minister. She wanted to brought many changes, and she brought a lot of changes which came to be known as mini constitution. Also otherwise known as the Constitution Act of 1976. The other names of the 42 Amendment Actors. The other name of the 42nd. Other names of what are the other names of 42nd Amendment Act? The Constitution. The Constitution Act 1976 is also known as the Constitution and 42nd Amendment Act. It was brought by Indira Gandhi. And this is like a most controversial. You always remember that the 42nd Amendment Act is the most controversial Amendment Act which has been come so far in the history. It had many things being changed. Some things has been taken away. The first is the 7th schedule of the Constitution. So first one the front page, that is front page of the Constitution, or the very basic structure of the Constitution is being added. It's being added like it added the word socialist. The preamble, it added the word in preamble, that is socialist, secular and integrity. That is the most important contribution of this act, because adding these three words, socialist, secularist and integrity, right? And it also transferred 5 subjects from the state list to the concurrent list, like education, forest, weight and measure, etc. Article 51A was inserted. Article 51A was inserted, that is fundamental duty. Fundamental duties being inserted by this act. And something has been lapsed later. First is regarding the president, okay, or the parliament. President, once an act is being passed, whatever being the decision with the cabinet, this act made that the president have to bound to the advice of the cabinet and he must follow it. There is no excuse or there is no something. Yes, Constitution, socialist, secularist and integrity. Fine. And what is this? Parliament is made bound to, so whatever the decision, whatever the thing is being decided by the president, or whatever be the thing is being decided by the parliament, the president must accept it. He does not have a provision to reject it. It was like a blow the existing system. It also allowed center to deploy central forces to the state deal with the conflicting situation. So if there is a conflicting situation arises, what happens? The center can directly intervene in a state and without the permission of state. And another important review, or the important point which you discuss on the 42nd Amendment, that It has curtailed the basic thing. What is the basic element of a high court? That is a review. The review power of a high court cancelled. Even though now it is being back, the 42nd Amendment made to cancel this power. It is another blow. This is a more important things, and one more important, 4 new DPSPs being added, and now we are continuing that 4 DPSP. Okay. Article 39, Article 39A, Article 43A, and Article 49. So simply I will tell you that is Article 39, 39A, 43A, and 48A. These are the articles which is being added by the Constitution. What is the thing? To secure opportunities. You are giving a healthy development for the children. To give secure opportunity. So DPSP, which is being added, amended by the 42nd Amendment, and it continues. So it is important to secure opportunities for healthy development of our children. First one is related to children. Okay. And legal aid to the poor to ensure the justice. You have to ensure the justice. To ensure the justice, you have to give equally promote the legal aid to the poor. Participation of the workers in the management of industries. Safeguard forest and wildlife. Simply you can have a code that is CPIW. Let it be the code. The 42nd Amendment Act, DPSP, you can code it like this, CPIW. CPI is a party, CPI is a party, right? There is a party known as CPI. So just remember CPI of West Bengal. This is a code, okay. 42nd Amendment Act inserted what? 42nd Amendment Act acted or added the DPSP, and that DPSP you can have a code. What is the code of the DPSP which is being added to the by the 42nd Amendment? CPI of West Bengal. CPI of West Bengal. That will be the code. So it might be more easy to remember. What is this? C stands for children. So children and healthcare, it is being given. So poor. P stands for poor. For giving health related assistance. What is this? I stands for industrial management. Industrial management. So try to have codes like this. So it will be very easy. So I think now you won't be forgetting it. So the DPSP which is being amended by the 42nd Amendment Act is CPIW. CPI of West Bengal. Okay, this is not party politics and all, but this is some codes which you can remember. This is how I remember things, otherwise you'll forget, right? Fine. So we'll go to the next question of the day. The Zonal Council has been established by Article 263 of 63 of the Constitution, State Reorganization Act, Zonal Council Act, and Order of President of India. Zonal Council have been established by Article 263 of the Constitution, State Reorganization Act, Zonal Council Act, and Order of President of India. Fine. Try to answer the question. No. It is established by State Reorganization Act. Yeah. Something funny, but that has happened. Zonal council have been established by zonal council. So what do you know about zonal council? What is this article 263? We'll see it. So zonal council. Zonal council are a council or which is being established by, it is a statutory council. Okay, zonal council is a statutory council. Zonal council means a statutory council. Yes, I'm a Malu. Yep. Yes, I'm a Malayali. Ate. Yes. So we'll discuss it further. The Zonal Council has been established by State Reorganization Act 5. Right. It is a statutory council. It is a statutory council. Remember this word. And it is established by an act of parliament. Established by an act of parliament. Completely established by an act of parliament. And the State Reorganization Act of which year? 1956. The State Reorganization Act of 1956. Fine. The act divided the country into 5 zones. So what are the specialities, what are the features of this act? The act has divided the country into 5 zones, that is northern, central, eastern, western and southern. And what is this other speciality? Provided a zonal council for each zone. It is providing a zonal council for each zone, that is northern, central, west, eastern and western. This is the main thing. So each zonal council will be having a home minister of the central government, chief ministers of all the states of the zone, 2 or more ministers from state in the zone, and administration of each union territory in the zone. Then this has been consulted by the 1956. Then the other a small question which I am asking, what about what about Northeastern Council? This is important to remember. The Northeastern Council is not passed by the State Reorganization Act, but by a separate act known as Northeastern Council Act of 1971. Northeastern Council Act. Okay, it is created by a separate act of the parliament which is known as Northeastern Council of 1971. It includes the members Assam, Manipur, Mizoram, Arunachal Pradesh, Nagaland, Tripura, and what other things. It is like an advisory bodies and that make recommendations. Zonal councils are like advisory bodies which make recommendations. Done. So you got an idea about this zonal council. Other option which is being given here is Article 263. What is this Article 263 all about? Article 263. Article 263 is about interstate council. State council. The Article 263 deals with interstate council. Fine. Mainly establish coordination between center and the state. So what is interstate council? Interstate council is a permanent constitutional body, whereas zonal council is a statutory body. Fine. This interstate council is a constitutional body. When was the year it was set up? It was set up in the year 1990 for the first time. It is set up by a presidential order. Once more, remember the Interstate Council, Article 363. So the Article 263 deals with the Interstate Council, and it is a constitutional body which was formed in 1990 by the presidential order, by a order of president, and under the recommendation of Sarkaria Commission. It is under the Ministry of Home Affairs. And there is a secretariat functions of zonal council. The secretariat functions of zonal council has been registered in the interstate council secretariat from 1st April 2011. I know that is not much important, but this is what you get an idea about interstate council. The state council is by a presidential order, whereas the zonal council is by a State Reorganization Act of 1956, and the fifth zonal council, that is the Northeastern Council, is by a separate act known as Northeastern Council Act of 1971. Any doubt? If you're having any doubt regarding any points which we discussed right now, you can ask me. Whatever the points which we are discussing is really helpful for you to write the examinations. Don't worry, only first two questions will be it. This is. Now we go and see the second question of the day. Like, which of the following, third question, okay, which of the following statements are correct? Parliament can increase a tax, Parliament cannot reduce a tax, Parliament can abolish a tax, Parliament cannot increase a tax, Parliament can reduce a tax. It's a bit confusing, right? Which of the following statements are correct? Parliament can increase a tax, Parliament cannot reduce a tax, Parliament can abolish a tax, Parliament cannot increase a tax, Parliament can reduce a tax. Option A, 1, 3 and 5. Option B, 4 and 5. And C, 2, 3 and 4. And D is 3 and 4. What is the answer? Fine. I think I have some small technical error in between. We'll start it. Third question, right? Which of the following statements are correct? Parliament can increase a tax, Parliament cannot reduce a tax, Parliament can abolish a tax, Parliament cannot increase a tax, Parliament can reduce a tax. Option A, 1, 3 and 5. Option B, 4 and 5. Option C, 2, 3 and 4. And D is 3 and 5. Very simple question. You don't want much explanation question. So which of the following statements are correct? Parliament can increase a tax, Parliament cannot reduce a tax, Parliament can abolish a tax, Parliament cannot increase a tax, Parliament can reduce a tax. What is your opinion on this? Bit confusing, but it's an easy question. Take a small time and just answer it. Answer for the question is 3, 4 and 5. That is, a parliament can abolish a tax, parliament cannot increase a tax, parliament can reduce a tax. All these 3 statements are correct. So parliament and taxation, which is the current taxes which is going on right now? Parliament and taxation. What do you have an idea about it? There was a news. I don't know how many of you have gone to it. A latest news. So I think I have to discuss it here. Now, the parliament has passed a bill. Recently, a bill is being passed by the parliament. You get a question which is being related to this. That is why the bill is known as taxation bill. Taxation bill, a new bill is being passed. It's on approval. What is this taxation bill is all about? So this is the first thing is why this taxation bill is being approved. This is being approved due to the COVID-19 pandemic, which is giving relaxation. See, why this tax question is being asked? Because it was there in the news. Okay, this is how the questions will be. Taxation bill is a new bill which is being passed by to amend the 8 taxation laws. This is like giving a relief during the COVID pandemic. What is it? It also prescribes a tax exemption for the contribution. So, if you are contributing to PM Care Fund, if you are contributing to the PM Care Fund, so you will be having a tax exemption. Taxation bill, that is, you will be having a exemption. Rajya Sabha returned taxation bill, and once it is being passed from the Rajya Sabha, it has been passed back to the Lok Sabha. Now that is this. There was an ordinance. Ordinance is being changed to the bill. So what are the highlights of the bill? Relief. First of all, the bill is relief. Extending extending deadlines. Extended deadlines for filing returns. Extended deadlines for filing returns for like linking PAN and Aadhaar card. Due to the COVID pandemic or to the situation, it has been given a relief to extend the deadlines for filling returns for linking PAN and Aadhaar card. Relief, extension deadlines for filing returns linked with PAN and Aadhaar card. The bill amendment, the provisions for income tax. Like if you are contributing to the PM Care Fund, your income tax will be what? It also gets some relief features. So now it has been given something known as tax on capital gains. Tax on capital gains. So what is this tax on capital gains is all about? So FIA, when you are transferring an FIA, you get the tax shall be 20% for the transfer of FII and 10% for specified funds. Thus, what is capital gains tax? So you having a capital, you are getting an income on that, and so you will be taxed. That is known as a capital gains tax in a simple term. That is FIA 20% and 10% specified. Surcharge for FIA will be capped at 15%. Surcharge will be capped at 15%. So surcharge will be capped at 15%. So we already have discussed some scheme known as Vivatse Vishwas scheme. It was for the direct tax regime. You can pay the tax. The extension was being extended to this December to 30, right? Vivatse Vishwas scheme. Sabke Vishwas scheme and Vivatse Vishwas scheme. Sabke Vishwas was coming under last year for paying indirect tax, whereas Vivatse Vishwas is for direct tax payment. It also helps with the changes of approved cess. Under that they will be unable to commerce business and all. What you is required, that is enough. So you get a probable question from this area. So I thought, okay, we'll discuss the current affairs too. So when the current affairs is there, this is the way they can ask the question. And now this is the way they are asking question. Answers 3, 4 and 5. Fine. Now we can go to the next question of the day. I hope the bill is clear with you. Which of the following statements are correct with regard to expenditure charged on Consolidated Fund of India? Don't worry, I won't give any explanation for this question because no, from yesterday onwards, and I am explaining this Consolidated Fund of India which belongs to Article 260 of the Constitution. I was giving a big explanation. I am also fed up. I hope you will be answering this question. It is subject to the vote of Parliament. It is subject to the discussion in the Parliament. It is subject to the vote of Lok Sabha only. It is not subject to the vote of Parliament. Option A 1 and 2, option B 2 and 3, option C 2 and 4, option D is 1 and 4. It is subject to the vote of Parliament. It is subject to the discussion in the Parliament. It is subject to the vote of Lok Sabha only. It is not subject to the vote of Parliament. Option A 1 and 2, option B is 2 and 3, option C 2 and 4, and D is 1 and 4. So answer for the question is so can I tell the answer for the question? Yeah. Answer for the question is, I think nearly one total. I think we have discussed nearly 100, more than 100 MCQs we have discussed so far, right? From Polity all and all. We'll be having a clear-cut idea on it. Means why this is part 7. So the answer for the question is C, 2 and 4. It is subject to the discussion in Parliament and it is not subject to the vote of Parliament. Consolidated Fund of India. Do you want an explanation? Why is this so? Discussed many times, so I think no need. Go to the next question, right? Correct statement regarding the difference between pardoning powers of president and governor are: the governor can pardon sentence inflicted by the court martial while the president cannot. President can pardon death sentence while the governor cannot. Governor can pardon death sentence while the president can pardon sentence inflicted by the court martial while the governor cannot. Option A 1 and 2, option B 2 and 4, option C 1 and 3, option D and 4. Correct and state regarding the difference between pardoning power of the president and governor. Governor can pardon sentences by the court martial while the president cannot. The president can pardon the death sentence while the governor cannot. Governor can pardon death sentence while the president can pardon sentences by the court martial while the governor cannot. Try to answer the question. Answer for the question is B, 2 and 4. The pardoning power of president. So this is always a confusing area. Fine. The pardoning power of president and governor. What do you mean by the term pardoning? So first you have to know pardoning. Pardoning means, the term means that, so if a person is feeling a guilt on an alleged crime or an illegal offense or other legal offense, and as the act never occurred. So this is a person is feeling a guilt for a crime. So you committed a murder, you are feeling a guilt for the crime. So he is requesting the government or the president, basically not the government but the president, please do forgive. For murdering Rajiv Gandhi, the people has been given that, and that pardoning power has been never considered. Pardoning power has been considered, I think, not considered. They are still in the imprisonment, right? Why pardon? Because see, sometimes they are considering deserving for them. That is, simply they are saying that pay their debt to society, pay their debt to society, pay their debt to society. Pardons are sometimes offered to a person who were either wrongfully convicted. So sometimes this persons might be not a real criminal. Unfortunately, circumstances make this person to be criminal. There is an incident based web series that was, I really forget it. This is a story like this. Okay, pardoning power used. An incident which is based on 2006. I really don't know remember the name. So anyway, sometimes the circumstances making a person a convict, and or sometimes he is wrongly convicted. So really, in reality, he may not have committed a crime, but unfortunately, he is protested, or he is forecasted as like this. Pardons are sometimes offered to a person who either wrongfully convicted or who claim they are wrongfully convicted. Like, we are going to see the pardoning power of India. The pardoning power of India is being mentioned in Article 72 of the Constitution of India. So Article 72 of the Constitution deals with this pardoning power of President. Article 72, be clear with it. So governor pardoning power is mentioned here in Article 161, whereas the president pardoning power is mentioned in Article 72 of the Constitution. Governor is Article 161 of the Constitution. Fine. What is the pardoning power of a president? So sometimes a person who is involved in the capital punishment. What is the capital punishment? Death sentence is the capital punishment. Pardoning power being denied for the cases. So the convicts of the Nirbhaya case has been requested for a pardoning, but it was being denied. President of India grant a pardoning, reduce the sentence of a convicted in a case of capital punishment. So a person is being given a double life imprisonment or any some other life sentences. Then this pardoning power is granting repetitive and remissions of punishment, or to suspend it completely. So there are different type of pardoning power being here. That is, the first one is simple pardon. So what is it? Simple pardon, completely absolving the person of crime and letting go free. Complete pardon means you are allowed to go complete. Pardoning power of a president is being discussed, and the first one is pardon. In this pardon thing, what do you think? You are allowed to completely move out of the thing. You are completely allowed to be a free person. Yes. Second is commutation. What is this commutation is all about? That is changing the type of punishment which is, that is, you are giving a death penalty, it can be changed to a life imprisonment. Commutation means a person who has been committed a crime is death penalty. Okay, but if I feeling that he don't want to be given a death penalty, and that has been a life imprisonment. Reprieve. Allowed execution of a sentence, that is usually a death. Delayed allowal, that is like this date is being given and okay. Usually destined for a guilty person to allow him to apply for presidential pardon or some other legal remedy to that he is innocent. You are given a time period. You are giving a reprieve means you are giving a time period. So first one is pardoning power. You are completely letting you for free. The commutation means your life imprisonment is being changed. Death penalty is being changed to a life imprisonment. That is an example of commutation. The third is reprieve. Reprieve means like you are feeling, you are giving the execution will be completed, but you are giving allowed a time or some time so that you can be free from it. Find, like you want to find a legal remedy, you can go and find a legal remedy of it. Respite. What is this respite means? Like if a woman is pregnant, so if a lady is being pregnant and she is being punished for the death sentence, will she be hanged out? Won't be hanged. It will be reconsider, or a person who is like a complete mental person, a person who is out of mind is being killed, a person who has committed a murder, whether he will be given life imprisonment or a death sentence. No, he cannot be given because of his health medical condition, that is a mental trauma he has been going through. So that is it. Then remission. What do you mean by this remission? What do you mean by this remission? So reducing the timing, like as 20 years, 40 years, a person is being life imprisonment. It is being changed to 20 years, 40 years to 20 years, 20 years to 12 years, changed. A small change is being changed, that is, the quantum of punishment is being reduced instead of changing the nature of punishment. Instead of changing the nature of punishment, the quantum of punishment, how the punishment is being changed. So let me tell you once more. Just remember, pardoning means completely letting you free. Commutation means changing the nature of the punishment, that is, death penalty will be life imprisonment. Reprieve means delaying allowed execution, that is feeling guilty. Respite means reducing the quantum or degree. Remission means you are giving a quantum punishment, that is 10 years given reduced to 5 years. Simple. Which all the cases can go and ask for this discretion under Article 72. All cases where punishment or sentence is by a court martial. So if it is by court martial, a punishment given by court martial can be given this. Executive power of the union. Executive power of the something related to power of the union. In all cases of life sentence, you are being sentenced to death. In all these cases, you can go and meet. You can ask for the pardoning power. One is for a court martial. You can give for the pardoning power. The second is for the punishment or sentence for an offense against the law relating to matter, which is executive power of the union government. All cases where extend sentences to death. All about it. The president. So you are able to clear with. Are you clear with it? What we are discussing so far? So next question, this is governor. So what about governor? What about governor? It is same like that of which is described in the Articles 161. Governor of a state has the power to grant pardons, reprieve, respect, dismiss, punishment. Okay. Governor cannot give a pardon for a death sentence, whereas a president can give. Question is whether this is a power to grant pardon is absolute or in. So any persons who are committing anything against the law, like the state government has a power to grant pardons, reprieve, respites of remissions or punishment, or to suspend, remit, and complete the sentences of any person convicted on any offences against any law. Also note that the power you cannot give a death sentence cannot be changed. It's all about the terms. Second question. Which of the following statement is or correct regarding the powers of a governor to reserve a bill for the consideration of the President? It is down in the Article 200. It is not a discretionary power of the governor. It is a compulsory engagement of the High Court. He can reserve any bill passed by the state legislature, like AS 1, 2 and 3, and 4, 1 and 3, regarding pardoning powers. President, reconsideration of the president. So fine, everything is going on fine, right? So we'll discuss the next question of the day. Which of the following statements are correct regarding the power of a governor to reserve a bill for the consideration of the president? It is laid down in the Article 200. It is not a discretionary power of the governor. It is a compulsory. It's compulsory if the bill endangers the position of the High Court. He can reserve any bill passed by the state legislature. Which of the following statements are correct? Okay. Regarding the power of a governor to reserve a bill for the consideration of the president. It is laid down Article 200. It is not a discretionary power of the governor. It is a compulsory if the bill endangers the position of the High Court. Can reserve any bill passed by the state legislature. Option A 1, 2 and 3. Option B 3 and 4. Option C 1 and 3. And D is 2, 3 and 4. Try to answer the question very perfect, right? A very simple question. Which of the following statement is all correct regarding the power of a governor to reserve a bill for the consideration of the president? Found in Article 200. It is not a discretionary power of the governor. It is a compulsory power of governor. It is compulsory if the bill ending position of the court. Can reserve any bill passed by the state legislature. And 3 and 4 options and 3. So can I answer the question? The answer for the question is, C. 1 and 3 is the answer. Which of the following statements are correct regarding the powers of a governor to reserve a bill for the president? It is laid down in Article 100, of course it is true, and it is compulsory if the bill engages of high court to consider precedent. What are the other terms? What are the other thing which is coming under this? What are the powers of a governor to reserve the bill? Power of governor to reserve a bill. So do you have any idea about it? What are the considerations? What are the things which is being given like that? So that is, what is Article 200? Do you know what is Article 200 is all about? So it gives 4 options, mainly 4 options to the president, sorry, to the governor. The first one is to assent a bill. Assent a bill. Second one is to withhold the assent. And the third one is to reserve the bill for the consideration of president and return the bill for the reconsideration of Lok Sabha. So mainly the Article 200 of the Constitution provide 4 kinds of discretionary powers. That is the 4 kinds of discretionary power to the governor. First one is to assent a bill. You are giving assent to a bill. Assenting a bill. Withhold the assent. Reserve a bill for the consideration of president and legislature for reconsideration. Legislature for reconsideration. Fine. All about Article 200, which you want to know, okay? Assent, withhold, president, legislature. In an order, AWPL. Simply that is it. Article 200 is AWPL. Fine. So what is this? What is this giving? So you are giving a bill to the president. So he may return that bill. If you are giving a bill to the president, he may return the bill, and together with requesting the legislature to reconsider the bill. A bill is being reserved to the governor. He is thinking, okay, the bill has some flaws. So what he can do? He can give it to the Lok Sabha, Legislative Assembly to reconsider it. And he can also suggest amendments. So he is feeling, okay, this all the things you can do it to it. So the bill become betterment. Or this is not good. And this Article 200 is much important for your mains perspective. Also, you get a questions on the mains perspective from this Article 200. A mains perspective article. Everything is a mains perspective. This is more important. So you may get a question around next year. What is it? The governor second to derogate the opinion of the governor. So many are asking the governor's power to stripping of this power of the government, but it is fine. So I think this is a small explanation will do. That's enough. The incorrect statement about Central Vigilance Commission set up under on Administrative Reformation Commission recommendation set up by Central Vigilance Commission appointed by Prime Minister. The functions in certain cases overlap with functions of UPSC. It is certainly a substitute for an ombudsman. It complies directly from aggrieved persons. Option A 1, 4 and 5. Option B 1, 2 and 4. Option C 4, D 4 and 5. Incorrect about Central Vigilance Commission. Not correct, okay. Incorrect about Central Vigilance Commission. What is the term of office of a Central Vigilance Commissioner? Try to answer the question. Answer for the question. B 1, 2 and 4. 1, 2 and 4 is the answer. The incorrect statement. The first statement is much incorrect. The other statements are also incorrect. Right. So what is the Central Vigilance Commission? Central Vigilance Commission is a statutory body. It was a statutory body which is constituted on the base of K. Santanam Committee. So say K. Santanam, constituted on the basis of K. Santanam Committee. And this is a statutory body by the Act of 2003 Act. What about the body? It is an independent body and it is only responsible to the Parliament. An independent body which is only responsible to the Parliament. An independent body which is only responsible to the Parliament. It is a multi-member body like Central Vigilance Commissioner plus 2 members. It is a multi-member body with Central Vigilance Commission as the head. Central Vigilance Commissioner as the head and 2 other members. Fine. So who is constituting the members? So a Prime Minister, members of the opposition party, or the leader of the member of the opposition party, and Ministers of Home Affairs. These are the ministers who is deciding whom should be the Central Vigilance Commission. That is, Prime Minister is the not only by the Prime Minister. Second statement is not right. President appoint him, but a committee recommend him. The committee is having Prime Minister, Home Affairs, Ministry of Home Affairs, then leader of the opposition party. Leader of the opposition house in the House of the People. Fine. So what is the tenure of this committee? The tenure of the committee is 4 years. Or until a person attained an age of 65 5 years, whichever is earlier. So they can inference or look into the case of Delhi Police Commissioner, Delhi Police Special Police Establishment. Fine. Under Prevention Act of 1988, something like that. Yeah, Prevention Act of 1988. So this is like the body. So I hope you got a clear idea about the Central Vigilance Commission. Right? You get another question. Which of the following civil services find mention in the Constitution? Indian Administrative Service, Indian Forest Service, Indian Police Service, All India Judicial Service, Indian Foreign Service. Option A 1 and 3, option B is 1, 2 and 3. Option C 1, 3 and 5, D is 1, 3. Indian Administrative Service, Indian Forest Service, Indian Police Service, All India Judicial Service. Fifth one is Indian Foreign Service. Which of the services are mentioned in the Constitution? Okay. Try to answer the question. All India Service. It's actually a very small question. A question you know. Get all the things. That is, answer is E 1, 3 and 4. That is All India Administrative Service, All India Police Service and Indian Foreign Service. That is All India Judicial Service and Indian Forest Service is not mentioned. Declare it. Article 312. Article 312 is being mentioning what is. What is this Article 312? What is the scope of Article 312? As a UPSC aspirant, must be knowing it. What do you know about it? Article 12. Simply, according to this act, a parliament can create a new all India service with the effect of resolution national level if it is being passed. See, even a national level judicial service is being can create it, but it is not being mentioned. Okay. All you want. The next question. In which of the following circumstances a member of UPSC without referring to the matter? If he engages due to term of office in a paid employment outside the suggested as an insolvent, unfit to continue in an office and by of infirmity of mind and body, if he becomes in a way concerned or interested in special contract or the agreement made by or behalf of the government of India or the government of state. Option A, 2 and 3, option B, 4 only. Options is 1 and 1, option D, 1, 2 and 3. In which of the following circumstances President can remove a member of UPSC without referring to the matter to the Supreme Court? Engages during his office term in paid employment outside the duties. Is adjudged in an insolvent if he is unfit to continue office by reason of infirmity of mind and body, becomes in a way concerned or interested in any contract by the government on behalf of the government of India or government of. Option A, 2 and 3, option B is 4 only, option C, option D. So option is C. Answer is C, 1 only. 1 only. Not much explain. We'll move to the next question. Which of the following are not concerns of the UPSC classification of services, promotion, trading, disciplinary matters, talent hunting? 4 and 5, B 1, 3 and 4, 1 and 3, 1 and 4. So what is the answer? Classification of services, promotion, training, disciplinary matters, talent hunting. Answer for the question is D, 1 and 4. Classification of services and disciplinary matters is not a part of UPSC. Fine. This is not at all about that is promotion, training and talent hunting is a part of UPSC. So the 11th question is bit fine. Simple question only. Match list 1 with list 2. Select the correct answer. The respective list. List 1 acts, list 2 is provisions. A, Indian Council Act of 1861 introduced hierarchy. B is Government India Act 1919 placed Indian affairs under the direct control of the government. Indian Council Act of 1892 introduced representative institution. Pitt's India Act of 1784 introduced provincial autonomy, introduced the principle of election. List 1 is, that is Indian Council Act of 1861 introduced hierarchy. Government of India Act 1919 under the direct control of the government, placed Indian Affairs. Indian Council Act of 1892 introduced representative institutions. Meets India Act of 1784. And the other one is options here given as introduced provincial autonomy, introduced a principle of courts A, B, C, D. Option A 412, 4321 is 421, B 12. 4312, B is 4321, C is 34121, and D is 3412. That's 412, is 43121, C 421, and D is 412. What is the answer for the question? Answer is A, 4312. Answer is 4312. Indian Council Act of 1861 introduced provincial autonomy. So we'll see what is Indian Council Act of 18. Council Act of 18. Just have a small analysis that and all will. What are the first important features of the Indian Council Act of 1861? It introduced three separate provinces. See, three separate provinces is being introduced. That is, or three separate provinces like Madras, Bombay, Bengal. Madras, Bombay, and Bengal will be brought into a common system. Added. To the Viceroy's Council, a fifth member was being added. Through the Viceroy's Council, a fifth member was being added. And the total members now onwards, it will be 17 members will be there. So, separate councils were established in the provinces. Northwestern Fondia Province, Northwestern Fondia Province. 1880. So, these are all the part of this. Three Indians were being there. That is, one was Raja of Banaras, Maharaja of Patiala, and C. Dinagar Rao. That is, three persons represented government. That is Raja. Three Indian provincial people were there. That is Raja of Banaras. Lord Canning was governor on that time, and Maharaja of Patiala, C. Dinkar Rao. Raja of Benares, Maharaja of Patiala, and Sri Dihar Rao of 1970. These people were being allowed to the council by the Indian Council Act of 1861. Got an idea about it. Then comes the next act that is gone. I think we have discussed Government of India Act 1919 many times, right? Don't want to discuss about it. Then we didn't discuss Pitt's India Act, right? Pitt's Act of 1784. I didn't discuss it here in this section. Somewhere else we have discussed, but not here. What is this Pitt's India Act of 1784? See, this Pitt's India Act of 1784 has demarcated or distinguished between commercial and political functions of a company or demarcated. It allowed the companies or the court of directors to manage, create a body. New body was being created that is known as board of control. A body known as board of control was being created to manage the political affairs. The act significant for two reasons. Mainly, the act is very much important for two reasons. That is, companies' territories in India's were for the first time called a British possession. It is called the first time it is called the British possessions. And for this most time it was given supreme control over companies' affairs and administration. It was given supreme control over companies' affairs and administration. Fine. This is the thing. So I hope much clear. This is assertion question. Okay, Niti Aayog is neither a statutory body nor a constitutional body. It is established by an executive resolution of the cabinet. Answer the following question using the code below. Both A and R are true and R is a correct explanation of it. Both A and R are true but R is not a correct explanation of it. A is but R is false. A is false but R is true. So what is the answer for the question? I think you don't want to require much time for answer this question. The answer for the question is A. Both A and I are true, but R is a correct explanation of Niti Aayog is neither a statutory body nor a constitutional body. It is established by an executive resolution of the Union Cabinet. So, what do you know about Niti Aayog? So, Niti Aayog has replaced something. What is this? What is the full form of Niti Aayog? National Institution for Transforming India. Niti Aayog stands for National Institution for Transforming India. Who is the chairperson? Prime Minister is the chairperson. Vice chairperson is appointed by the Prime Ministers. Like ministers of all the state, lieutenant governors will be the part of this council. Ad hoc members are two ex officio capacity, having leading research institutions a part of this. Ex officio membership for maximum 4 Union Council of Ministers to be nominated by the Prime Minister. So this is, so we had a planning commission. This planning commission ended up being replaced by this Niti Aayog. Fine, it is by a resolution. Next question. The Constitution of India is a quasi-federal, given more powers to the central government than to the state government. Answer the following question using codes of both A and R are true, and R is a correct explanation of A. Both A and R are true, but R is not a correct explanation of A. A is true, but R is false. A is false, but R is true. Constitution of India is a quasi-federal, it has given more powers to the central government than to the state government. Both A and R are true, but R is a correct explanation. Both A and R are true, but R is not a correct explanation. A is true, A is true, but R is false. A is false, but R is true. Answer for the question is A. Both A and R are true, but R is the correct explanation of A. Then the next question. The Chief Minister can dismiss a Minister of State Government. Chief Minister is head of a State Council of Ministers. Both A and R are true. R is a correct explanation of A. Both A and R are true, but R is not a correct explanation of A. C is true, but R is false. A is false, but R is true. I think this is not much to discuss. Answer is which of the following correct with regard to the functions of UPSC? To conduct examinations, appoint for the services of union, to assist states if requested in and operating scheme, joint recruitment for any service which is candidate possesses special qualification are required, advise the union and state government on all matters relating to the methods of recruitment, civil service and for civil posts. Present annually to the president a report as the work done by it. Option A 1, 2 and 3, option B is 1, 3 and 4, and C is 1, 2 and 4 is 1, 3 and 4. Answer is D 1, 2 and 4. Which of the following writs is not specifically provided in the Constitution? Prohibition, mandamus, quo warranto, and injunction. We had discussed all these stuff, so I don't want to take one more. The answer for the question is section was useful to see. Let me tell you the explanation which I'm giving, minute points which I'm giving during this question explanation is going to help you out for the next prelims. And because we are having a detailed minute points being discussed. And can use my user IJU and get a 10% discount on any of the subscription. So for any of the subscription you can use it and you get a 10% discount. Fine. So have a great day ahead. Follow me on the Telegram group and the Unacademy profile. Use this and get 10% on any favors. The winding up the sections, the notes will be sending up. Now it's right now itself.